All right, good morning, everybody. So we're finally here. This is the last video one of these video reviews that I will do because this is the last day of class you all will have before the AP test on Monday. So after the AP test on Monday, you will be all finished. There will be no additional assignments. We scrapped the conspiracy theory project for those of you taking the AP test because we ran out of time here at the end with the changed schedule. So this will be it. I'm going to go over today Unit 3. On Monday, you will have your test. Test is at 4 o'clock on Monday. Please make sure that you do some studying this weekend so that you are prepared for that. On Monday at noon, I will be starting a Google Meet. I'll be up at the school. I'll have a Google Meet set up. If you have any questions, last-minute things you want to go over with me, jump on there. Obviously, you are free to email me in advance of that, any questions you have. I've actually gotten several of those today, so some people are actually getting some work in, which is good. There is one thing I need all of you to do this weekend. Very, very important. This is probably the most important thing that you will do for this entire AP test. Is on Saturday at 4 p.m. You need to check your email or you need to check your AP classroom. You should be receiving your invitation to take the AP test with the link and everything that you need for the test. That will go out at 4 p.m. on Saturday. They might send it out earlier than that. I doubt it. Don't look for it in the morning and think, oh my God, I didn't get it. Chances are it won't come before 4 o'clock, but that will be your 2-day notice for your invitation for the AP test. Now, as soon as you open that email, okay, that is saying I'm taking the test. So, and I'm taking this test in 2 days. So, if you know for some reason for some reason you can't take the test on Monday for whatever reason, don't open that email. Okay, when you open that email, that's going to be your confirmation. But if you know you're taking the test on Monday, go ahead and open the email. You don't have to click on the link because that's going to be the link that takes you out to the test. You don't have to do that 2 days early, but just make sure you get the email. If you don't get the email, make sure if you go out to AP Classroom that you can see it. If you do not see it, you need to get a hold of me this weekend. Mr. Summer and I are both kind of on standby. We can contact the College Board. You can contact the College Board directly and let them know that you didn't get it, but we're happy to assist you with that as well if by some chance you didn't get that email. So that is going to come Saturday at 4 p.m. For your Monday test. So please make sure you are checking for that. Now, before I do Unit 3, which Unit 3 I'm going to kind of skim certain things because a lot of Unit 3 are all the Supreme Court cases, which I did a review over earlier this week. So if you need a review over those court cases, go back and review the video from, I believe it was on Tuesday, I want to say, was the Supreme Court case. It might have been Monday, but Monday or Tuesday was this week. Before we start, though, I want to correct a mistake I made in yesterday's video. I mixed up two things when I said it. I was going kind of fast at the end. Thank you to Samantha for emailing me and correcting this. When we were talking about the trustee model of government versus the delegate model of government. So in the trustee model of government, representatives act as trustees for their people, meaning that these trustees have the freedom to act as they see fit. Okay, in the delegate model, people are expected to act the way that their constituents want them to act. And I flipped those yesterday. So I want to make sure that I correct that because that was a mistake that I made. I was going kind of quick at the end of the video there, and I flipped those when I said that. So trustee model, people are given the trust of their constituents to basically act as they see fit basically on their behalf. In the delegate model, people are asked to act in a way that their constituents want them to, specifically on certain issues. So I just want to make that correction. If you jotted any notes down from yesterday, please make sure that you have that correct definition in there. I apologize for that. I was trying to shoot 3 of these in a row for my 3 classes last night, and I flipped those around. So, okay. Today we're going to move on. Unit 3, Civil Liberties and Civil Rights. This is going over a lot of the cases we did in these last few chapters. So, again, even though they removed the question where you're going to have to specifically talk about a case and compare it to another case that you don't know, that question's not there. But the chances that they're going to have a question on a Supreme Court case is very high on this test. So either you being able to use a Supreme Court case in your response for the argumentative essay, or you being able to incorporate a case that they're going to mention in question 2. So chances are you're going to see something. So knowledge of those key 15 cases is critical. You are obviously free to use any other case that we talked about in class that wasn't part of those core 15. You can definitely pull any of those things as well. So this section has 13 units here. I'm going to kind of go through these as quickly as we can so that this isn't super long for you guys today. It starts with the Bill of Rights, and we know, of course, that when the Bill of Rights was written, it applied only to the federal government. It did not apply to the states. The process of selective incorporation slowly, piece by piece, started to incorporate the Bill of Rights to the states. Now, as we discussed in class this year, there are still amendments to the Bill of Rights that have never been applied to the states, the Third Amendment being one of them, because state governments have never tried to quarter troops in someone's home. Therefore, nobody has had standing to sue over that issue. So, again, the issue of standing is critical when we talk about any court case, but particularly when looking at selective incorporation, is you have to have a legal challenge that they need to address. So, first learning objective here, explain how the U.S. Constitution protects individual liberties and rights. Now, we talked about civil rights versus civil liberties. Civil liberties tend to be anything that is associated with the Bill of Rights. Generally, we think of it as the First Amendment, but it could technically be any of the amendments in the Bill of Rights. Most civil liberties cases are something having to do with free speech or free religion or free press, something directly related to the First Amendment. But again, they don't have to be something with the Bill of Rights. Now, civil rights cases tend to be things that are related to the 14th Amendment, so Equal Protection Clause or things like that. So civil liberties almost exclusively first, but definitely something in the Bill of Rights. Civil rights are primarily 14th Amendment. So it says civil liberties are constitutionally established guarantees and freedoms that protect citizens' opinions, property against arbitrary government interference. And remember the debate about the Bill of Rights. So between the Federalists and Anti-Federalists, the Anti-Federalists believed that it was essential to the process of our Constitution. The Federalists obviously did not believe that. They believed that a lot of the rights that were spelled out in the Bill of Rights were already in the Constitution. And when we did our Federalist, Anti-Federalist debate earlier this year, a lot of you pointed some of those things out. So we had some pieces that were already there, and they made sure that those, the Federalists made the argument that those things would suffice. We didn't need this additional thing tacked onto the Constitution. Well, obviously it happened. So obviously, you should know at this point what's in the Bill of Rights. You've taken 7 amendments quizzes this year, so obviously that's something that you can keep handy if you need to. I would hope at this point none of you need that, but if you need to keep your amendments handy with you when you take this test, obviously I would recommend doing that if you don't know them. So Constitution obviously being one of the required foundational documents for the argumentative essay, you could incorporate those as you see fit. Okay, so 3.2 talks about freedom of religion, and we get into the 2 parts of the First Amendment that talk about religion, and we have the Establishment Clause versus the Free Exercise Clause. So the Establishment Clause obviously says that the federal government cannot establish a religion for the United States. The Free Exercise Clause says that the federal government cannot prohibit you from freely exercising your religion. So those are the cases that we tend to get before the court will associate with one of those 2 concepts. So the big 2, and again, of the 15 cases you're required to know, 2 of them are freedom of religion cases. The first one being Engel versus Vitale. This is the one where the school tried to open the day with a prayer, and the Supreme Court struck that down, said that was a violation of the Establishment Clause, is that a public entity was trying to force prayer upon students, and that was something that was unconstitutional. We also had the case of Wisconsin versus Yoder, and that was the Amish student case. Now, I mentioned that case. That case was not specifically in our textbook. I went over this a few days ago in the video I did over the Supreme Court cases. But we did talk about this case just in general. I didn't give you the name of it at the time. But Wisconsin versus Yoder was the case that said Amish students are free to leave school after 8th grade. Their religion says that they're supposed to start working for the family at that point. So even though we require students to go to school, not public schools, but go to school in general until they're 18 or they have a high school diploma, if your religion says otherwise, then we're going to allow you to freely exercise your religion. So by saying that Amish students had to attend school, that was a violation of the Free Exercise Clause. So that was the case of Wisconsin versus Yoder. So those 2 cases are significant and they deal with freedom of religion as it's spelled out in the First Amendment. So again, make sure you know Establishment Clause versus Free Exercise Clause, what those terms mean. Free speech. We've talked obviously a lot about this here. Not all speech is protected. There are things that are not protected free speech. We talked about that in the context of one of our cases here. Down here at the bottom, it mentions Schenck versus the United States. Schenck v. U.S. was the case that established that notion of clear and present danger. If your speech could harm another person, then that is not protected speech. So that was established in 1919, the idea of clear and present danger. But for the most part, speech is protected. Okay, you do have the right to protest against government. You do have the right to speak your mind on various issues. And that speech does not stop when you go to school. You have First Amendment protections at school as well. That was the Tinker versus Des Moines case back in 1969. Now, obviously, if your speech is disruptive to the school day, then the school can do things to limit your speech if they know that it's disruptive. But the issue in Tinker versus Des Moines was this idea of prior restraint, is that a school district was trying to limit someone's speech before they did anything. So this was the black armbands case, and the court ruled that you can't do that. So you can't restrict someone's speech before they say it. This was also involved in our freedom of the press case that we talked about in New York Times versus United States, with having to do with the Pentagon Papers. The court struck down the ability of government to restrict speech before someone said something. So that idea of prior restraint. So make sure you understand what that idea means as to what prior restraint means. Now, as I said, there are limitations to free speech. Down here at the bottom, it gives you some of those limitations. Obviously, we talked about clear and present danger as it relates to the Schenck case. Above that, any defamatory speech. So if I am slandering or libeling you, that was the New York Times v. Sullivan case, then that is not protected free speech. But again, that's very hard to prove. So you have to prove that the speech was harmful, that the person knew that the speech was false, and that it was published with actual malice. That idea of the fact that I knew it was false and I did it anyway. I did it to harm you. That's not protected speech. But if you can show that you didn't know one or more of those things, then that would be protected. Okay, so any speech that is offensive, obscene gestures, things like that are not necessarily protected speech. And then it talks about the fact that we have time, place, and manner regulations. And what that means is that certain speech may be okay at certain times, but it may not be okay at other times. So if I'm standing in a crowded movie theater and I yell fire, obviously that is not protected free speech. But if I'm, I don't know, sitting out in the middle of a field and there's people around and I yell fire, well, who cares that I yelled fire if we're outside and nobody's around? So it's one of those things that, again, there are time, manner, and place regulations that could make speech free or not free. So obviously, foundational document here is still the Constitution. This is all First Amendment stuff. And then we have our two required cases as it relates to this topic here. Okay, that being the Tinker case and the Schenck case, which are very important cases there as well. Okay, 3.4, First Amendment freedom of the press, and this goes, again, very similar to what we just talked about. This introduces the New York Times v. U.S. case. And again, you can work in New York Times v. U.S. You can also work in New York Times v. Sullivan, even though that isn't one of the required cases. You can definitely talk about that. New York Times versus Sullivan was our actual malice case about Martin Luther King, in which the New York Times published a story about city officials from Alabama. They brought suit against the newspaper saying that they were slandered because a few things in the story were incorrect. The New York Times did not publish that with the intention of being incorrect. It was not, the information they were given, the vast majority of it was correct, and they published that not thinking that a few things might have been wrong. So the court ruled that they have the right to do that. That's not slander. It's not libel because it's something that was done not with the actual malice. So you can use that case as well. You can also definitely use the New York Times v. U.S. case when talking about anything related to freedom of the press. This was the Pentagon Papers case that we just talked about having to do with prior restraint. So those are, again, the freedom of the press in this country is protected, and that's something that our government really takes seriously. All right. Second Amendment, right to bear arms. We have a couple of cases here that we talked about. The big one you need to know is McDonald versus Chicago. So McDonald versus Chicago was our 2010 case. that extended the Second Amendment to the states through selective incorporation. So basically, this is something that the federal government and the state government cannot restrict the right of a person to bear arms. Now, there are restrictions that they can put in place, though. If they want to require background checks at the state level, that's fine, because states handle licenses. If they want to require gun licenses or they want to require different restrictions that go with that, that is also fine. So as long as they're not prohibiting a person from owning a gun, they can put restrictions on that, the same way that when we talked about abortion, as long as you're allowing abortions within the first trimester, you can put restrictions on it. That's fine. You can make it harder for a person to do it, but you can't keep them from doing it. The same thing kind of goes with guns and the way that we interpret that. So again, Second Amendment, right to bear arms, that has been upheld by the Supreme Court fairly recently. It was 2010 that case made it through the court as it related to the gun owner in Chicago. Okay. 3.6 talks about amendments balancing individual freedom versus public order and safety. So this is, again, a lot of the Supreme Court cases that are heard are weighing one person's constitutionally protected right versus another person's constitutionally protected right. So it gives you some examples here. So in this first part here, it says the court has had to deal with decisions defining cruel and unusual punishment and involve interpretation of the Eighth Amendment. So what is cruel and unusual punishment? Well, the answer is it depends. It depends on the state that you happen to live in. So there's a case that we didn't really focus on this year. It was the case out of Georgia, Gregg v. Georgia, which basically said that the death penalty is okay, that the death penalty is not cruel and unusual punishment. And that's been interpreted differently at different times in American history. But ultimately, where the court stands right now is that individual states can decide. And a lot of states ban the death penalty, but other states still allow it. And it's really a state decision because it falls under that idea of police powers, health, safety, and welfare. So that's a state thing. But again, you have a constitutionally protected right against cruel and unusual punishment. So the court has had to weigh that Eighth Amendment protection versus the state's rights to regulate police powers and have to decide who wins. Second Amendment and Fourth Amendment are also amendments that we've looked at that kind of weigh sometimes individual rights versus group rights. So particularly when you see Second Amendment arguments, one of the big things that you see is an individual's right to own a gun versus maybe a restaurant or a store's right to prohibit people from coming into their store with a gun. So we know that individuals who own businesses have protections of their business. They have the right to decide what happens in their business, but you also have the right to own a gun. So the court has had to decide who wins in circumstances like that. Fourth Amendment as well, unreasonable searches and seizures. What is an unreasonable search and seizure? Obviously, if you're a terrorist and you have a bomb and the police believe you have something and they search you without a warrant and they stop you from blowing something up, we know you're probably going to get off if they search you illegally, given what our system says. So the court has weighed individual rights sometimes over punishing a criminal in certain cases. There have been many, many people in this country who've been let go who we know committed crimes, but they've been let go on technicalities because the court has really strongly upheld these Fourth Amendment protections as to what is an unreasonable search and seizure. And sometimes individuals will be let go who are clearly guilty of a crime because they can't prove that this is the case. We can't prove it without that evidence. And if that evidence gets thrown out in court, then you got a problem. So we talked about some cases here. So we looked at the Miranda v. Arizona case that threw out his confession because he didn't know that he had the right to remain silent. So that was kind of falls under this idea as well. It wasn't search and seizure, but it was something that was tossed out in court the same way that evidence would be thrown out in court. So remember we talked about some of those concepts. So fruit of the poisonous tree. If I obtain evidence illegally, anything that evidence leads to is also inadmissible in court. So that concept is really critical in court as well. So make sure you understand this idea of we've got a couple arguments here. Is that oftentimes one person's rights are being weighed against another person's rights when the court has to make decisions. 3.7 is selective incorporation. So obviously this concept is critical to the process of how the Constitution works. So originally, Bill of Rights only applied to the states. starting in the early 1900s, the court started to slowly incorporate the rest of the Bill of Rights to the state government, so that states cannot violate your Bill of Rights protections as well. So this process is known as selective incorporation. The way you should talk about this, if you're talking about selective incorporation on the AP test, and you can see it here when it talks about enduring understanding, the court has used the 14th Amendment to selectively incorporate the Second Amendment, for instance, to the states. So the 14th Amendment's Due Process Clause, Equal Protection Clause, are used to selectively incorporate amendments to the states. Okay, that's kind of the process by which it happens. So it says here, the doctrine of selective incorporation has imposed limitations on state regulations of civil rights and liberties. So that idea is key here. So the idea being that you have due process rights. Okay, we established that in the Fifth Amendment. We restated again in the 14th Amendment. Okay, you also have equal protection rights. So if one layer of government can't treat you differently, then the other layer shouldn't be able to treat you differently either. So we use those ideas that are put forth in the 14th Amendment, particularly this idea of due process, to make sure that you can't, that these portions of the Bill of Rights get passed on to the states. So the portions that still don't apply today, and there are several of them, are pieces of the Bill of Rights that have never been challenged because people lack standing, as I mentioned before. Okay. 3.8, amendments relating to due process and rights of the accused. So big things here from the Fifth and Sixth Amendments, particularly relating to these ideas. So if you look here on the right, it says the court has on occasion ruled in favor of states' power to restrict individual liberty, as, for example, when speech can be shown to increase the danger to public safety. So we talked about certain cases there. That was obviously the shouting fire in a crowded theater. They can restrict your speech there. But then there were other cases, like the Brandenburg v. Ohio case with the KKK, where they didn't do that. They said that as long as they weren't threatening a specific person, that they would allow that speech to be okay. The Miranda Rule involves interpretation and application of accused persons' due process rights as protected by the Fifth Amendment. Okay, so Fifth Amendment, you have due process rights. Sixth Amendment, you have the right to a fair and speedy criminal trial. And the court has ruled that a violation of Miranda rights violates your right to due process and a fair and speedy trial. So the court has been very, very strong in upholding individual protections. Now, it says here that the court has sanctioned a public safety exception. And we talked about that earlier. So let's say I don't read someone their Miranda rights because time's in a crunch. I really have to get evidence really quickly. A person's going to die in 10 minutes, something like that. They might allow that evidence in court. They may not still. Okay, it's going to be up to a judge, but they may allow that evidence in court. Big thing with public safety exception is they will allow evidence in if somebody inadvertently tampers with evidence without meaning to. So let's say you have a crime scene and there's a pool of blood and a person just got stabbed. Paramedics and police arrive on the scene, and in order to try to save that person's life, because they're still alive, they trample through the blood, and now there's footprints in the blood, and they've kind of contaminated the crime scene, not intentionally, but they've done it to try to save a person's life. A good defense attorney is going to say, well, my client, their footprints may be in the blood, but so are 3 other people's. Well, the courts are going to say, well, okay, that's a public safety exception. We're still going to allow that evidence in, even though there are problems with the evidence, because they didn't mean to do that, okay? So we have that issue of public safety. Down at the bottom, it talks about pre-trial rights of the accused, and the prohibition of unreasonable search and seizures are intended to ensure that citizen liberties are not eclipsed by the need for social order and security, including the right to legal counsel. Okay, so everybody has the right to an attorney. That was established in Gideon versus Wainwright. You have the right to a speedy and public trial, and you have the right to an impartial jury of your peers. So a jury that doesn't already believe that you're guilty. Protection against warrantless searches of cell phone data under the Fourth Amendment. Okay, so today, particularly since the Patriot Act, we've had a lot of challenges in court. So today, they cannot search your cell phone data without a warrant. That's a requirement now. And then limitations placed on bulk collection of telecommunication data. So after we found out what they were doing under the Patriot Act, there was a very strong push and challenges in court which restrict the government's ability to do certain things, such as just simply telling AT&T, give me everyone's text messages. We'll sort through them. You have to have a warrant. You have to have specific warrant showing that I believe this person committed a crime. This is why I need this information. You have to very specifically have those things. But again, it talks about up here additional cases, Gideon versus Wainwright. Okay, that's the case that required everyone to have the right to an attorney, whether it's a death penalty case or not. It also talks under 3.8 about some more due process things. It mentions Gideon versus Wainwright in here. Exclusionary rule. That's a very important concept. The exclusionary rule basically says that evidence that is obtained illegally in the United States is automatically excluded from trial. So we're not going to examine that evidence. That's not the case in Great Britain. In the British system, they will look at that piece of evidence in the context of everything else that they have against you. And if that piece of evidence backs up other things they have, then they're still going to allow that in. But in the United States, exclusionary rule, the same concept as fruit of the poisonous tree, we're automatically going to toss that out. We're not going to use that evidence here in the United States. So big idea there, exclusionary rule. Obviously, we talked about Gideon, so you should know everything else here on this page. 3.9, due process and the right to privacy. Remember that the right to privacy was established in that case of Griswold versus Connecticut. That was our case having to do with contraception that was being sold in the state of Connecticut. The big thing about that case had absolutely nothing to do with abortion, but it established that individuals have a right to privacy in their home. Now, initially that was marital privacy. They extended that later to privacy in general. Okay, and that really laid the groundwork for Roe v. Wade. So when we get the Roe v. Wade case coming down in 1973, remember that it established that trimester system for pregnancy. So in the first trimester, there can be no state restrictions on an abortion. Second trimester, the state can, and oftentimes states do, put restrictions on abortion, but they still have to allow abortions if the health and safety of the mother is at risk. And then third trimester, the state can say there can be no abortions at all. That's a state decision on that topic. But again, what allowed them to get there was that they had established this right to privacy in Griswold v. Connecticut. They basically said that Roe v. Wade, what a woman does with her body, is a privacy issue. Okay, so more so than it being anything else. So obviously, people can make the argument that a fetus may have rights to equal protection, the same way that a person would have. The court, if you remember, the court said we're not addressing that issue of when life begins. Okay, that's a political question. We're not touching that. We're just analyzing the information we have in front of us, and we're going to say that this is an issue that has to do with right to privacy. Remember this piece of legislation right here, Hyde Amendment. Hyde Amendment was something that Congress passed in the wake of Roe v. Wade. Obviously, they didn't amend the Constitution to undo it. But what they did do is they passed the Hyde Amendment, which basically says you can't use federal funds to pay for abortion. There are a couple exceptions to that. Obviously, if the mother could die, rape or incest, things like that, they would still allow it. But the general rule of thumb is that no federal funds can be used to pay for abortion, which sometimes can limit public facilities from performing abortions based upon that restriction. 310 talks about social movements and equal protection. This is where we work in Letter from Birmingham Jail. So I had you read that. You answered some questions about that. You should know that document. Anything, particularly if you get an argumentative essay, talks about anything related to civil rights and civil liberties. This is where you can work in Letter from Birmingham Jail. You can work in any of our cases that talked about civil rights and civil liberties, particularly as whatever they happen to be talking about. But if it's anything having to do with race, you can obviously work in that document. You can talk about any of our affirmative action cases. We had the Bakke case that ruled that affirmative action is okay if you use it as a +1 system, not as the only rule for what would allow someone to be hired or accepted to a college, whatever the case may be. Hey, so remember, civil rights is protections from discrimination based upon race, national origin, religion, and sex. These rights are guaranteed to citizens under the Due Process and Equal Protection Clauses of the 14th Amendment, as well as acts of Congress. So the question then becomes, what are some other things that have not been included in there? Obviously, as of this moment, we have not included LGBT rights. Those are things that the people are discussing those pretty regularly, but they're currently not protected by the Supreme Court under what they call equal protection as it relates to certain groups. So they treat LGBT individuals differently than they treat individuals who are discriminated on the basis of race, religion, sex, or national origin. So those are still different categories that we utilize today. So letter from Birmingham Jail, again, a lot of our interest groups that some of you have. So if you had NOW as your interest group, if you had the NAACP as your interest group, those are obviously groups who did things that are related to the issues of civil rights, that you can work some of those things in here as well. But again, 14th Amendment, generally, if you're anything related to civil rights, okay, you're looking at 14th Amendment protections and what that means. Hey, go back and review Birmingham Jail. You did that assignment on that. That will definitely help you. Government responses to social movements. We talked about the fact that generally when something happens in society, government tends to respond to it, obviously, and the court, even though they don't have to, the court oftentimes pays attention to public opinion, and they start to change policies based on social movements. So obviously in 1896, Plessy versus Ferguson said that separate but equal facilities are fine. By the 1950s, public opinion on that issue had changed, and we talked about a lot of reasons why public opinion had changed. But when we get to the 1950s and we get the Brown v. Board case, the court's going to change their mind, and they're going to say that separate facilities are inherently unequal, that you can't have separate but equal facilities and have things actually be equal. So remember, in the Brown v. Board case, they use that Dahl test to show feelings of inferiority, which are a violation of equal protection. So that was a key part of that decision in 1954. Now, 1964, remember with the Civil Rights Act, and again, you did a lengthy assignment on this, so you should have that handy as well, have access to that during your test if you need it. But the Civil Rights Act had those 10 provisions of different things that are protected in which you can't discriminate against people. So it looked at education, it looked at accommodations, it looked at restaurants, it looked at government facilities, things like that. So there were all sorts of things in the Civil Rights Act, and Congress passed that because, again, public opinion had changed. It wasn't that Congress was diverse, because they weren't. Most of Congress in 1964 was still old white guys, but public opinion had changed, and because of that, Congress was influenced in order to change their tone there. Title IX, it talks about, we mentioned this Title IX briefly when we talked about sex discrimination. Title IX of the Education Amendments Act of 1972 basically says that there needs to be equal numbers of men and women's sports within schools. The men's basketball coach and the women's basketball coach have to be paid the same thing. We know that there are circumstances where that's not the case today. But again, schools have to have the same number of men and women's sports. We talked about why Northmont has, for instance, volleyball as an officially sanctioned state sport for girls, but it's not for boys. It's basically club at Northmont, because that's kind of girls volleyball is kind of the counter to football. So there has to be an equal number of boys and girls sports. So volleyball for boys doesn't count per se, because we have to have an equal number of sports. Now we still have a club team. It's treated a little bit differently in the way things work. But again, that's the rules as it relates to sex discrimination. Voting Rights Act, 1965, came a year obviously after the Civil Rights Act, and it fixed some of those things that the Civil Rights Act didn't do. So remember, the Civil Rights Act said, hey, stop doing things that treat people, that make it harder for African Americans to vote. So stop doing things like, you can't just give literacy tests just to black voters. You can't just have poll taxes paid by black voters. Well, they continued to do this, and they were still knowing, particularly in some communities, that lower income people who were illiterate, tended to more often than not be black in some of those southern communities. So what the courts did is that what the southern states did is they were still basically violating the law without actually doing it word for word. So in 1965, the Voting Rights Act said, okay, you got to stop all this stuff altogether. So obviously the 24th Amendment is going to ban poll taxes, but we're going to get the restriction of literacy tests that are going to come from the Voting Rights Act as well. So these were all, again, government responses to social movements. The public was clamoring for something, and government responded. 312, balancing minority versus majority rights. Obviously, we saw that with separate but equal. That was a big part of the Plessy case and the Brown versus Board of Education case. We also look at this in the instance of gerrymandering. The court has ruled that racial gerrymandering is unconstitutional. So even though the majority party can have power in drawing districts that benefit the majority party, you cannot do it in a way that disadvantages demographic groups within a country. So that's a protection that's in there. So it says down here that the Supreme Court upholds the rights of the majority in cases that limit and prohibit majority-minority districting. So again, that's racial gerrymandering. That's the term that they use there, majority-minority districting. So anytime you're taking race into consideration in terms of how you draw congressional lines, that's going to be unconstitutional. They're not going to allow that. That's not going to be protected. Okay, and then finally, 313 talks about affirmative action. Amy mentioned this a second ago. This was the Bakke case that's mentioned over here. So the Bakke case basically said that what University of California was doing with their medical school was that they were setting aside a certain number of seats for minority applicants. The Supreme Court's going to say that that's unconstitutional because it's treating people differently on the basis of race. But the idea behind affirmative action, the Supreme Court said, was good. So if you are doing affirmative action programs in order to fix historical wrongs, then the court supports that. But they had to figure out a way for you to be able to do it without violating the Constitution. So what they came up with was this idea of the +1 system. So I can't say that I'm going to set aside a certain amount of spots for minority applicants. What I can say is that I'm going to use race or gender or whatever the case may be as one factor out of a group of 10 or 15 factors that I'm going to use to decide my applicants. So if I have 2 applicants and they're basically equal, so let's say I assess GPA and activities in school and all these other things, and everything is deemed to be just about the same between these 2 people, but one of them is in a historically underrepresented group, I can choose that person basically as the tiebreaker between the 2 applicants who were there, who were kind of on the bubble between the 2 of them. So that is okay. That is the court ruled in the Bakke case. That's okay. But you cannot use it as the sole criteria for choosing or not choosing a person. Okay, so that is Unit 3. That's pretty much civil rights and civil liberties. Obviously, there's a lot here to unpack. You have to make sure that you know the amendments, you know the articles of the Constitution, what's in there, what is the process of how we go through selective incorporation. That is very, very critical. And you need to know those cases. So I've got the cases. I showed you that street law site back on Monday or Tuesday, whichever day we did that earlier this week, that goes through all the cases in a lot of detail. If you have specific questions about the cases, shoot me an email and let me know. Okay, that covers pretty much all of the review walking through these 3 units. So if you have any specific questions, obviously the next 3 days I'm available basically 24/7. You can get a hold of me. Monday from 12 to 3, I'll be on Google Meets. I'll also be answering emails that you have. So if you have emails you don't want to get on there face-to-face with a bunch of other people, that's fine. You can email me your questions. I can get back to you there. I'm going to stop that Google Meet at 3 o'clock to give you time to kind of take a break before you start your test. I want everybody to log on at 3:30 on Monday. Get on there at the beginning. There could be issues with the site crashing if there's overloading of things. We don't know exactly how this is going to work. This is the first time they've ever done this. They say they've tested it. We'll find out. So everything I'm hoping works well. But I'm going to need everybody to jump on there at 3:30 on Monday just to make sure that you're on there and ready to go. Okay, if you have any questions, let me know. Hope everybody has a great weekend, and I will talk to you all on Monday.